So where we left off last week was we're still on the buyer sellers advisory form. Last week we missed because of the forecast, but the week before that, and we spent a little bit of time finishing paragraph 8, which was the non-confidentiality of offers, or the confidentiality of offers. I gave you my 2 cents worth. We didn't really have much time left for discussion on this. So if anybody had any questions or comments on this, because I know this can be controversial. This is the type of thing, if you're a listing agent and you have multiple offers, it wouldn't surprise me if you do get into a little bit of a heated discussion on how that's handled by the buyer's agent. And then of course, if you're the buyer's agent, quite honestly, you may have a completely different opinion and thought process to the one that I shared last week, which was, for those of you that weren't here with us, when we went over this 2 weeks ago, was I am a believer that the best process to handle multiple offers is one of confidentiality. Now, that is a thought and a process that is certainly espoused by most listing agents, which I tend to put myself into that category. But again, the heartburn that I expressed last week is if you were on the buyer's side of the transaction, you always want to know what the other offers are. You always want to know, are you the highest? Are you the lowest? Are you in the middle? What do you got to do? How many times have you had that question? Hey, where do I need to be? Tell me where I need to be so I can tell my buyer. So I understand that it's not a one size fits all response. But I don't see anybody unmuted. So I'm going to assume you guys are comfortable with how we presented that. And we're going to move forward. So, okay.
Sorry, I missed it. I apologize. Wanted to ask what says here the instruction of the seller. So,
Yep.
How would you obtain the instruction of the seller?
Well, this is the deal. This is a conversation that I believe all listing agents need to be having with their sellers. And quite honestly, over the last several years, I think it would be a conversation that you had every single time. And quite honestly, a conversation that you would have, in my opinion, best practice is to have this conversation at the listing presentation. So Javier, if you're my seller, the conversation would go something to the effect that, hey, Javier, we're super excited. I can't wait to move forward. We got a list price of, $910,000 and hey, guess what? At this price range and in this market, I expect us to get more than one offer, and we can go down that entire path. I would then lead into, oh, by the way, assuming we do get more than one offer, this is how I recommend we handle the processing of those offers. And I could frankly go directly to this paragraph. I could incorporate the seller signing of the buyer seller's advisory as part of that presentation and say, let's talk about paragraph 8, Javier, and what that means to you. My recommendation as your agent is that we keep the offers confidential, and this is why. And it's very hard, to be honest with you, if there's anything that's one-sided about this, in my opinion, is 100% in the seller's best interest to keep the offers confidential. Okay, because what is the seller ultimately is creating is a blind bidding war. And you've got buyers bidding against each other, bidding against themselves. So from a standpoint of kind of quote unquote selling it to the seller, it's an easy sell. You just go through and you explain the process, and ultimately it's 100% in the seller's interest to do this. And if they're not completely convinced of that, I would tell them my real life experience. I said, hey, for 20 years, I represented Fannie Mae and Freddie Mac on the sale of their foreclosure properties in the Inland Empire. And the policy that I'm recommending that you follow is the policy, quite honestly, that really didn't even exist before the foreclosure crisis, if you will. This was a policy that was created by Fannie Mae and Freddie Mac. And they created it in an effort to be, frankly, what was in their best interest as the seller of these properties. So I presented, I could go on for 20 minutes on how I would pitch this to the seller, but in effect, it's in the seller's best interest. This is why it's in their best interest. And I haven't even talked about, if you were on our training class 2 weeks ago, and I talked about the mechanics of it, and I maybe spent a little bit more time talking about the mechanics as a listing agent. You guys, we've all had listings over the last several years where we've had 10, 12, 30, 40, 50 offers. And under those circumstances, keeping offers confidential is almost a risk management requirement, because if you are not keeping all 30 offers confidential as a listing agent, the chances of you making a mistake in fairly relaying what the other 49 offers are, or the other 29 offers are, to all 30 agents or all 40 agents involved in the transaction, the reality is it's impossible. Because if you keep, let's again, let's just keep it more simple. We have 10 offers on a property. They either are all confidential or they're all not confidential. You can't pick and choose. So once you decide that you're going to share what the other offers are, which one of them are, oh yeah, hey Javier, this would drive me crazy, guys. This would happen to me. We have a property in the office, and it's a hot property, and I'm the listing agent, or Drew's the listing agent, and we have 10 offers on it, and one of those offers is from a Coldwell Banker Town and Country agent, and they would come in and say, hey Lance, what's the best offer? Where do I need to be? It would drive me crazy. And of course the thought process would be well, come on, we're all town and country, and you're the broker, and it's in everybody's best interest. Well, yeah, that's true, but I don't want to be pulled up in front of a grievance committee at the Association of Realtors, basically being accused of not treating all offers fairly. You have to do that. I don't care whether they're in your office or whether they're part of a team you're on. If you end up in a situation where any of those other offers, rightfully or not, is accusing you as a listing agent of not treating their buyer fairly, or their office fairly, because they're with RE/MAX and you're with Coldwell Banker, and you treated, Irene's offer, basically Irene had inside information. Oh my gosh. So for that, and let alone a buyer after the fact. I see you're unmuted, Irene, give me just a second. So you don't want to have a buyer accuse you after close of escrow that said, hey, I wrote my offer with Sally Real Estate, and you sold your offer to Irene's buyer with Coldwell Banker, and I think you did me wrong, and I'm going to file a complaint with the Department of Real Estate, and I'm going to file a complaint with the Citrus Valley Association of Realtors. Guys, you don't want anything to do with that. So you want everything you possibly can do to be as fair and transparent. And by the way, transparent in this case means nobody gets any information. Okay. Again, we could do a 2-hour class on this alone. Irene, let's take your question and maybe one others, and then we'll move on. What do you got?
No, Lance, I just want to express that I rather do the confidentiality one, because I believe, there was one client, just from experience, and me, I'm a newer agent, and a buyer wanted I picked up the buyer at another agent's listing, and all of a sudden she wanted me to go in with the other agent as a co-agent, which was fine, because I was still learning, and I'm good with that. But however, the buyer's idea was to be able to get an upper hand on what other listing, what the other bids were. And
Right.
Straight from the top, we told her no. I ended up losing it because she was mad because the listing agent wasn't, which was my co-lister, was not biting. She was like, no, So, and so just be prepared. That's how they do it. Or also just go with somebody else. And they rather go with the listing agent, and they rather do a dual, with the listing, buyer, seller, whatever. So that's just my quick one.
Well, and that's the quick one, but that's a super common one. And again, just to put an exclamation point on this, is if you're representing a buyer in this transaction, or if you are the buyer in this transaction, if you go back and listen to the end of our session from 2 weeks ago, I fully acknowledge that this is a horrible position to be in. You don't want to be that buyer who doesn't know. And frankly, you don't want to be the buyer who's wasting their time, or you don't want to be the agent who's wasting your time. And this is where a lot of agents get frustrated. And I totally understand the frustration. But the frustration is a simple one. Lance, the house is listed for 900. I know you've got 10 offers on it. I've written you an offer for 890. It's the best I can do. Are we wasting our time? Tell me. And they kind of sort of know they're wasting their time. Or even if they're like, hey, I've written you an offer for full price. I've written you an offer for 900 grand. I know you said there's 10 offers. Are we wasting our time? Because if it's going to take 3 more days to figure this out, I would just want to take my buyer right now, and I want to take them over and sell them something else. I understand that. It makes perfect sense. Unfortunately, once you start sharing that information that says, oh yeah, you are, the highest offer is 920. Okay. In theory, you think you're doing them a favor because you don't want to waste their time and you like them, and don't waste your time. Well, that same agent who said, hey, I can't go above, 900, and I don't waste my time, just please. And as soon as you tell them it's 920, and you didn't tell the other 8 or 9 offers it's 920, that agent now rewrites a new offer, and then they submit it for 921. And then by the way, they work in an office with a bunch of other agents, and they're sitting next to them. Oh, by the way, hey, I just talked to Lance, and highest offer is 920. So these are how these things get out of control, and they get bad. And I'm not making stuff up, guys. I've done, no joke, thousands of these type of transactions with multiple offers. And this is the way to do it. Okay, I think we've whipped that horse to death. Hopefully you guys will follow my lead. Javier, we'll let you put you go ahead, Javier. You have one more comment or question.
Super quick question. What about when somebody says, do you have a higher than asking, lower than asking? What do you say to that?
I don't say anything. So this is how it would work. Let's just keep it simple. I have 5 offers on the property. Our procedure is very simple. We have a form. It's not a zip form that you can find in CAR forms. And it's the same exact form that Fannie Mae and Freddie Mac uses today. Same form. And it's basically highest and best offer. It's got, I think, 4 items on it. Number 1 offer. And this is a form that goes to the listing agent. So I sent it to all 5 listing agents. It says, hey, Sally Smith, listing agent. Number 1, we're acknowledging that we have more than 1 offer on the property. Number 2, we're acknowledging that, or you are acknowledging, because we want the listing agents to sign off on this. You are acknowledging that you have until whatever time you put in there. You have until Friday at 5 p.m. to give us your highest and best offer. We then tell them that if you want to change your offer, get it in, do it in writing. If you don't want to change your offer, so if your offer is the best offer already, please let us know that this is your best offer. And then the last part of it, it says, we do not do, for example, we're going to get to this, I think, in next week's class. We haven't gone through the counter offer things, I don't believe yet. We do not do seller multiple counter offers. Okay. I don't like seller multiple counter offers. We'll talk about that later. I prefer, so by the way, if you follow my lead and you use a highest and best procedure, as opposed to an SMCO procedure, seller multiple counteroffer procedure, if you go that direction, then number 1, you'll never have multiple counteroffers at the same time, because the very last item of the highest and best procedure basically says we only work with 1 offer at a time. So Javier, if you were one of 5 offers, we would give you that form. All 5 offers came and they gave us their highest and best. Okay. If Javier, if your offer was the best offer, we would do one of 2 things. We would either accept your offer, say your offer is accepted, we're not putting out multiples, or we would give you a counter and you a counter offer alone and say, your offer is the best, but we want to change one thing. And then we'd give you a very short period of time. We'd give you, 6 hours to accept or reject. And if you accepted it, great, you're in. If not, then we go to the next offer. We go to Veronica's offer. We do the same thing, and we do it quickly. So if we give you a deadline of Friday at 5, our expectation is, Friday at 6, we're going to have a fully executed contract. And if not, by Friday at 9 p.m. or whatever, we're going to have that communication. Oh, we're not going to do it. Great. We're going to the next one. We're going to the next one. We only work with 1 offer at a time. Again, I'm not a fan of seller multiple counter offers. Not that they're horrible. Frankly, they've become industry standard. That's kind of what we use. I mean, I see them all the time when I'm in SkySlope. But and they're good, if you will, if done properly and if everybody understands. But you guys also understand, you put a seller multiple counter offers. A lot of agents don't even understand what that means. They get it, their buyer signs it, they turn to the buyer and says, hey, congratulations, you just bought yourself a house. No, they didn't. The seller still, of course, has the opportunity to reject that. So I'll tell you what we'll do. I don't have it handy. I will add into Contract College forms. I'll bring it in for next week's class. I will add to our slide deck here the actual multiple counteroffer form, and I'll show you how that form works. And I just encourage you guys to take a look at it. So I just think it's the best way to go. Okay, so let's keep on rolling here. Online wire funds transfers. So this is again another disclosure that's within the buyer seller's advisory that in effect says, hey, best practice, we're going to do wire transfers. Don't bring us cash, don't bring us personal checks. Make sure you're very careful with your information when you're sending and receiving wires. Same sort of stuff we've been talking about. We've already gone through our form WFA. So this is just a restatement of being careful with that. Other factors affecting the property. Again, we're getting into this repetition phase where we're covering these in different forms. So is the property in a community enhancement district? Those are those special assessment districts for tax purposes. Is there a private transfer fee? I believe we talked about private transfer fee last week, spent a little bit of time going through that. So this is what this is referring to. A lot of detail in here. Ironically, they've got their Fannie Mae Freddie Mac rule. I just mentioned Fannie Mae Freddie Mac with the multiple offer procedure form. So they've got some stuff in here in relation to that. It's another kind of one of those forms that, or one of those items that just kind of becomes minutia, where these poor buyers and sellers just get overwhelmed. I've got a section here on the bottom of page 12 talking about defective or recalled home items, furnaces and microwaves and water heaters and that sort of stuff. This is one of those areas where it's a good opportunity for you to, in effect, say, hey, this is the deal. This is one of many reasons why we should get a home inspection on the property. I am not qualified to tell you whether the furnace is up to snuff, whether it's on a recall list or whatever it happens to be. The home inspectors are professionals in these areas, and this is why we're asking them to do that. It is kind of funny. This is one of those items, though, that in the past was a bigger deal. 15, 20 years ago, it seemed like there was just every house I was selling, something was being recalled. Something was just, something was bad. Seemed to have less and less of those. But one thing to be careful with, especially in a lot of the homes that we put in escrow, buyer or seller, are older homes. Okay. So if you're selling an older home, the chances of you having a component within that house which is outdated, or actually a component that has been recalled and is still in the house functioning, are higher. So again, a good opportunity here to talk about the importance of getting a home inspection. This just gives the client a little bit more period of time on getting more information and refers them to some home inspection stuff and a consumer protection safety board with some information here. Ties into that. More information about homeowners association, again, very repetitious, talks about, getting a look at those CC&Rs and taking a look at the bylaws. And, for example, it talks about FHA-VA approval. This is one of those. And one of the things I want you guys to keep in mind as use these forms to trigger your own memory, or use these forms to learn things as you go. For example, when I look at this portion of this form, it's a reminder to me that not every homeowners association is FHA-VA approved. Okay. And some of you on this Zoom right now may not realize that. Hey, I'm selling a condo. I sold another condo in the same complex. I sold it to a conventional buyer. Everything went through. Everything was fine. It's a beautiful complex. Everything is great. Now I'm going to sell another condo in that same complex. You think you're a pro because you've already done one, but now your new buyer is getting FHA financing. Well, is that condo complex approved for FHA financing? So this is one of those things where even though I've been doing this for a long time, this might be one of those triggers for me to remember, oh my goodness, maybe I better check. Not maybe I better check. I'd better check. I'd better check to make sure that this project is approved for FHA VA financing. So again, the general spirit of this paragraph is in effect to let the buyer and seller know that if they're within a homeowners association and there are CC&Rs in their bylaws, to read them, make sure they understand them. You know, what do they mean? What are the responsibilities? What can I do? What can't I do? You know, can I park my boat in the driveway? Whatever it happens to be. It's a continuation of that same paragraph. You know, talks about the association's ability to put a lien on your property. Hey, if you don't pay your association dues, guess what? They can lien you. If you live in a homeowners association where you're not allowed to park your RV or your boat in your driveway overnight or whatever it happens to be, they can fine you. Those fines can become liens, and those sort of things. I'll point out the CID. Those are those acronyms again for some newer agents. I always warn you guys, if you're new and I used the acronym a couple of times today, CC&Rs. Don't repeat acronyms if you don't know what they are. Covenants, conditions, restrictions. Well, what's a CID? Well, a CID is a common interest development. Same as a HOA, homeowners association. Same and similar as a PUD, plan unit development. So whether you're a new agent or whether you're becoming a little bit more of a seasoned agent, don't fall into the acronym trap. Okay, if you don't know what the acronym stands for, take a moment to find out. If you're talking to your escrow officer and they use an acronym that you're not familiar with, pause. Don't just say, oh yeah, sure, I'll get that, you know, because you don't want to embarrass yourself. Ask them, you know, what did you just say? I'm not familiar with that acronym. You might embarrass yourself, but this is how you learn. Okay, so again, this is just more information on the homeowners association disclosing to the buyer and the seller. Paragraph talking about legal action. Buyer and seller is advised if the seller is a previous owner involved in legal action. So this is telling the seller, is there anything going on this property? Is the pool builder suing you? Is the homeowners association have a lawsuit? Is there a construction defects litigation against the builder? Whatever it happens to be, any sort of litigation or a previous buyer. Hey, yeah, I'm under litigation. I had this thing in escrow 2 months ago and it fell out. I'm being sued by the other buyer. All of those things need to be disclosed up front on what that action may be. Again, we've talked about this multiple different places within the contract. What kind of marketing we do? Are there photographs on the internet? Are there photographs on social media? Yes, yes, yes. It just is what it is. I think everybody's pretty much understands that. Have we talked about this before? Yes, I already talked about the PACE loans, the HERO loans. Again, PACE, there's another thing. Again, here I am talking about acronyms for just a second. I was trying to remember, what does the PACE acronym stand for? Property Assessed Clean Energy, PACE, okay? Reality is we don't have a whole heck of a lot of PACE in Southern California. PACE is a Northern California phenomenon. We have more of the HERO programs, which is funny. I forgot what the HERO acronym stands for, and it doesn't look like they have it spelled out here. I think it's home energy something. Anybody know what HERO acronym stands for? Again, I don't know that it's relevant, but that would be the type of thing, because I'm a nut when it comes to this. I would do a quick Google search on what the HERO acronym stands for. PACE is more of a Northern California thing. HERO is a Southern California thing. You got to know. Okay, you got to know that. So maybe somebody do a Google search and come back here and tell us what HERO is. I think home energy something. So at any rate, do we have any of those loans or liens on the property? What are we looking at when it comes to that? Rekeying the property, basically telling the buyer, hey, guess what? At close of escrow, you get the property rekeyed. We don't know who has keys, you know, they've been running around, you know, did somebody pick up a key that's not supposed to have a key? So get the property rekeyed. Oh, and by the way, unless there's some allowance for this, that's going to be at the buyer's expense. So always a good thing. I always would make that part of kind of like my closing package with my buyer. I'd say, oh, by the way, we're closing escrow. Here's the phone number to Don's Lock and Key if you want to have Don come out and rekey the property. And, you know, I'd get a little bit of a discount or something from Don, try to do my buyer solid with that, but, you know, get the property rekey. Solar panel leases, kind of sort of going back to the PACE program, the HERO program. Are they there? Are they leased? Are they owned? Again, we've already discussed that. Recording devices, they're referring to cameras. Are there cameras in the property? It's funny, just before the class, I have online cameras on all 4 offices and my 2 properties that I can take a look at anything. It's all recorded. It's all sitting there. You know, I got a picture of my dog walking in the backyard. So is it going to be recorded? Also, are those recordings going to be going on during the marketing time? Okay. Meaning you've got a buyer walking through a house, they're on the back patio, well, there's a camera up there and the seller can hear everything that the buyer and the agent are talking about, how much they're going to offer and all the rest of that sort of stuff. So what do we have there? Some local disclosures, insert as needed. And now we're at the end of page 14. So buyer seller sign, we've now completed our statewide buyer seller advisory, 14 pages. In case you guys didn't notice, hey, Mike, go ahead. Had a question.
HERO stands for Home Energy Renovation Opportunity.
There we go. Home energy renovation opportunity. So interesting. Just a real quick one on that. Thanks for looking that up for us, Mike. They seem to have kind of disappeared a little bit. I mean, man, they were all the rage. And you'd go to your mailbox and you'd open up your thing and you'd see your little brochures from all the builders and I'll put your windows in, I'll do this and that. And every single one of them had a HERO stamp, hero, hero, hero. I mean, it was crazy. You don't see that. You just don't see that anymore. Oh, thanks, Javier. I see you plugged it in there as well. Home energy renovation opportunity. Excellent. Okay, one last thing real quick. On this page, you guys are already aware of this. They changed this form a few years ago. I can't remember exactly when they did it, but this is the longest form, disclosure form that we have, 14 pages. It only requires signatures on the last page. Okay, it used to you have to initial every single page. They got rid of that. So just buyer and seller agent signatures on page 14, and that suffices. Okay, I'm going to keep on rolling. So this is where we've kind of swapped up the order. When we do the next class, I am probably going to reorder the forms a little bit, but I wanted to make sure we're hitting the big ones. So we're going to jump into the addendums to the purchase agreement next. Okay. Next time I do this class, after we do the actual RPA, rather than jump into the disclosures, which is kind of what we did, I'm going to actually move this part up. So we'll do the RPA and then we'll jump into the addendums to the RPA. So I will reorder this next time around for those of you that come around for part 2 of our contract college. So we're going to start with the probate. And then there's the manufactured home and a variety of other ones. So we'll see how far we get today. So this is form PAPA. Probate agreement purchase addendum. Now, previously, there was a completely separate probate contract. So you would get the RPA probate version. Now we don't have that. Now and I think this is an improvement. This is one of the things that I think CAR and their forms and legal team did well, is they said, hey, we're gonna keep with the RPA, and then we're just gonna create an addendum for probate, et cetera, et cetera. So let's go through it. Just a quick little, not a word of caution, a word of encouragement, okay? A lot of our newer agents, and quite honestly, some of our seasoned agents, when they start to get outside of a normal residential purchase agreement, they get nervous. Oh my gosh, it's a probate. Oh my gosh, it's a foreclosure. Oh my gosh, it's a short sale. Oh my gosh, there's a notice of default, whatever. And you guys have a little bit of a panic attack, okay? Take a deep breath. They're really not that much different. So as we start to go down to these specialties, and in this case, a probate, there are several things you need to know, but none of them are overly complicated. So don't be afraid. Oh my gosh, I've never done a probate. I don't want to do it. I'm going to refer it over to somebody else. Okay. Call me, call Drew, call Paul, call Drake. Let us walk you through these. Okay. This is how you're going to get experience with this, and we're going to help you out through the entire process. Keeping in mind, unless you're completely focused and marketing to probate attorneys and you're in that market, the chances are you're not going to do a whole lot of these. Okay. They might pop up, once every other year, if at that. So what are we doing here? So this is an addendum to the purchase agreement. So by default, we're amending the purchase agreement. You could amend something else, but they have the opportunity to check other and insert something else here. I don't even know what that would be. I guess I could think of something, but we're going to be amending the purchase agreement. So back on the RPA, we would be checking the box that says we've incorporated the probate agreement to the purchase addendum in here. The date that goes here is going to be the date of the RPA. Property address, of course, seller's name, buyer's name. So what do we have here? Buyer and sellers are referred to as the parties. So right off the bat, we're identifying what is the type of probate that we're dealing with. Okay, so we're reading through the form. The probate is part of what? The descent. Oh, by the way, let's back up. I'm assuming everybody understands the property's in probate because somebody died. Okay, and when they died, they did not have their affairs in order. Okay, they didn't have a will. The property wasn't held as tenant or joint tenants. They, in effect, they left that unresolved, which is just, it's just torturous when that happens. But at any rate, so somebody has died and their estate is not in order. So what's the status of the decedent's estate? Okay, so it's part of an estate. So we've got basically 4 options here. The first one is the property is part of the decedent's estate. Okay, Sally died. She didn't have a will. She didn't have a trust. It's in Sally's estate. Okay, or it's in part of a conservatorship. Okay, so you could have a conservatorship for Sally. Maybe she's incapacitated, or Sally's not dead, Sally, but she's not able to act on her own, or it's in a guardianship or receivership. These are all very similar. Okay, conservatorship, guardianship, receivership. We're not going to necessarily get into the distinction of these, but they're all very similar. And generally, these are all going to be determined by some sort of previous court action. Okay, so this property is put into conservatorship, or a guardianship would normally be for like a minor or something like that. So what's the status? And again, you don't have to check one of these. If it's just the decedent's estate, then you don't check any of these. You just leave it in, hey, Sally died, no will, no trust. There it is. Okay, if the property is being sold as part of the decedent's estate, paragraph 3A applies unless 3B is checked. Now we're going to get to 3A and 3B in a minute. So it's given us some instructions on what to do when we get to paragraph 3B and 3A. If the property is sold through a conservatorship, guardian, or receiver, so they're setting those up separately, then the court confirmation is required. Okay, so with a lot of probates, court confirmation is required. For the most part, if that's not going to be defined when you're getting involved in this transaction, that's one of the very first things that you need to figure out. Most of the time, and frankly, I would suggest all the time, somebody representing the state needs to have legal counsel. All right. You're not going to be legal counsel on this. You're not going to be defining these terms. You're not going to be telling them what them to do. You want these instructions to be coming from the attorney handling the probate for the survivors within the estate, which is generally how we get involved normally. Normally, we get involved kind of after the fact. Now, if you are looking for a marketing plan, marketing to probate attorneys, well, there you go. Because then you get the business directly from the attorney. You know who the client is, even though the attorney is not the client, but technically, what are you going to do? You're going to follow the attorney's lead, and they're going to tell you exactly what to do. If let's say that the son or daughter of Sally comes to us, hey, mom died and blah, 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 and I need to sell the property. Well, you're going to ask a few questions, is it an estate, blah, blah, blah. And if ultimately you've kind of determined that, okay, this is definitely a probate, if they haven't already volunteered this information, it's okay, well, do you have an attorney? Well, no, I don't have an attorney. Okay, well, quite honestly, that's a full stop. That's a full timeout. Okay, you need to reach out to a probate attorney and you need to get instructions. We're not attorneys. We can't advise them. We cannot appear in court. We're not going to go get court confirmation. We don't do that. We couldn't even go to court and appear for them, even if we wanted to. The first question the judge would ask us is, are you an attorney? Well, no, I'm the real estate agent. But you're not even allowed to be here. You need to be a legal representative of the court, an attorney, in order to do that. So is court confirmation going to be required? And again, this is why I tell you guys, if you've never done one of these before, don't be nervous, because at the end of the day, whatever gets done is ultimately going to have to be approved through the legal process anyhow. Okay. If the property is, if the property of probate is incorrectly identified in paragraph 1A, so in other words, we thought it was a conservatorship, but in reality it was a receivership. Okay, so maybe we got bad information. Maybe the child who was trying to deal with this didn't know. Okay. So anyway, so it's so funny because obviously this happens quite often. It happens so often. How many forms do you know of? Quite honestly, I think this is the only one that I can think of. Maybe we'll run into another one in a minute that actually specifically says, if you made a mistake above, this is how we're going to fix it. Right. I don't, it's pretty, I think it's almost kind of funny. So obviously this happens often. So if we made a mistake identifying, is it a conservator, guardian, receivership, or part of the estate, the seller shall inform the buyer of the correct type of the probate no later than the time of the disclosure of the agreement. So it almost kind of implies that, hey, relax. If you got it wrong, once you figure out what it is, just make sure you let the other parties know. And it kind of implies that, hey, it's no big deal. And in reality is, it's no big deal. The court will sort that out. And then of course the probate advisory form is included. That's this second part of this form. And by the way, guys, I'm going slow, but if you have questions, just ask. So here we are on the court confirmation section. So court confirmation, undetermined at the time of offer. Okay. So if we don't know exactly what we need, then this is where we're going to go. So again, seller shall deliver written notice to the buyer at the time of the acceptance or within the time of the seller delivery of the documents of the time period of the court confirmation is or is not required. So if you're not sure, which by the way, sometimes you're not, it's early on in the process. So the gist of this is you're going to kind of get one of two things from the attorney handling the estate. The attorney is going to say, guess what? We are approved to sell this property for $900,000. If you can sell it for $900,000, the court confirmation is not required. In other words, they've already approved it. Okay. Or they're going to say, we're approved to list it for $900,000, but any offer below 900 or any offer at all, we need to take that offer back to the court. The judge will, normally there's an appraiser involved. They're making sure that their estate's being represented properly. They're making sure they're not selling the property maybe to a family member for a low price or something like that. Somebody's not getting taken advantage of. And that's what this really is all about. So that will be determined at the time you take the listing. And if it's not, then we're going to basically put everybody on notice. At this point, we don't know. We don't know whether we're going to need court confirmation. But as soon as the attorney for the estate tells you one way or the other, then you will disclose that, of course, to the buyer. Okay, so if court confirmation is not initially required, notice of the terms and sales of the beneficiary heirs is still necessary. Okay, so what they're referring to there, and again, you don't do this. This is going to be done by the attorney representing the estate. So what they're talking about there, Sally passes away. Sally has 6 kids. Okay, they want to make sure that all 6 children are aware of what's going on. So kind of that example I used a minute ago, the child number 1 comes in and wants to buy the house for $500,000. It's worth $900,000, thinks they got a great deal. Super, super duper. Okay. Well, kid number 2, 3, 4, 5, and 6 are like, what's this? Why is Jim getting to buy the property at a discount? That's not fair, because the proceeds that $400,000 difference would have been separate, split up among the surviving heirs. That's what that's referring to when they want to get in. They want to make sure that those surviving heirs understand. And then again, you'll see their opportunity to object. I can't remember who the agent is. And maybe you're on this training. We have an agent right now where we have, I don't think it's a probate. It might be. I can't remember exactly. I think it's not. No, it's not in the probate, but it's in a trust. And there's 2 sisters involved. And one of the sisters is not happy with the other sister, who's the trustee, doesn't feel that that sister's moving along fast enough. And that sister's got some health issues, and the other sister has hired her own attorney to challenge the other sister's authority to manage the trust as the trustee. This happens all the time. Okay. Now it's a little different situation when it's in a trust, but it is kind of sort of the same thing. So Diane Speaker had a property with, I think, 6 or 7 siblings in an estate. I'm not kidding, guys. Took, I think, 10 years. 10 years to liquidate. And it was not a cheap property. It was a multi-million-dollar piece of property in the city of Redlands. They all hated each other. They all had their own attorneys. Everybody contested and objected to everything. It was a nightmare. Okay, so keeping going on. If after the sale is made, seller notifies the buyer that court confirmation is required, then court confirmation becomes part of the transaction. So again, if you're representing the buyer or the seller on this, just go into it thinking it's going to require court confirmation. And whoever you're representing, you want to get documentation from the court that says that. Okay, so in other words, you have a document that says the court confirmation is not required, or yes, court confirmation is required. So make sure that you have that documentation. You've got to have it. Now, if you know right off the bat that you have the document that says yes, it's required, then you're going to check the box. It's going to say that it's required and that it's contingent. Pretty straightforward stuff. So, and by the way, the portion that we just discussed really truly is kind of the crux and the difference in these type of sales. But the attorney for the estate is going to answer these questions for you. You do not determine this. Okay. So they're going to answer it for you. It is really truly the key difference. Then it talks about if and when court confirmation is required. Well, what does that mean? And does it add some time to the process? And the answer is absolutely yes. It adds time to the process. Now, I will tell you, I don't know if anybody's done one of these recently, but I'm hearing all sorts of delays and things that used to take, a week that are taking 2 months when it comes to processing and getting paperwork through the court. That's certainly the case on the eviction court. I don't know if the probate court and the family law court are as backed up as the eviction court is, but that's who answers that question, by the way? The probate attorney representing the estate. So is 15 days enough? Whatever it happens to be. Is 10 days, are those going to be enough days to get that done? Okay. So just make sure. And again, if you represent the buyer or the seller for that matter, just make sure you're telling your client, hey, this is the deal. We're going to do the best we can. We're going to stick with it. And I hate saying that, by the way, when it comes to contractual dates, but these things truly are out of your hands. You truly are out of your hands. So what you think is going to take a month could take 2 or 3. Hey, Irene.
Okay, real quick question. I know we had discussed a situation when I was talking to you about a probate as well, and it's complete. So now I guess now a title is in both sisters' names.
Okay.
So even though it's just a recent probate that was completed, would
Okay.
they still need some form of documentation saying when it was completed and where would it go?
Okay, well, that's okay. So wonderful question. This is why I love these type of engagements. Okay, so what I've been referring to is not what Irene just referred to. Okay, the probate that we're talking about in this particular transaction is a probate that is still in process. Okay, the property has not been dismissed or released from the probate. We're actually selling the property through the probate process. Okay, that's what we've been talking about in this document. What Irene just described is very common, by the way. So mom passed. We have 2 sisters involved. The house is not for sale yet, not for sale. So the sisters have received a probate attorney. They're going through the process to get that property through the probate and basically get it in the hands of somebody. And if I understand Irene's situation correctly, that process does not involve the sale of the property to a third party. Now, this is kind of sort of easy peasy and I don't know if this is the exact example that Irene has, but let's just suppose mom passed and the only people that are descendants of the estate are the two sisters. And let's suppose the two sisters generally get along, okay? They're not going to kill each other. One of them's not trying to take advantage of the other, et cetera, et cetera. So that goes through the probate process. What the judge determines is that who are the heirs to the estate that could have a claim to this? Okay, well, it's only the two sisters. It goes through and the judge says, okay, great. You guys are agreeing. Nobody's objecting. You're all on the same page. We're going to basically grant you two sisters title to the property and basically going to transfer the property to the estate. So in that case, assuming I understand Irene's situation correctly, and I think I do, the property has been discharged through the probate already. And now the property is owned by the two sisters. So if that's the case, you don't need any of this paperwork. So you're selling this. This is a regular listing agreement in your case, Irene. It's going to be signed by Sally's sister and Mary's sister. They're the sellers. Now, what you might want to have, which is what I would have, is I would have the court document that says the property is out of probate and that the two sisters now own it and have legal right to sell it. But if that's what's happened, then you don't need this document. The probate is over. The property has been dismissed from the probate.
So
Is
it's
that
good
correct?
just to have that document on hand, just in case
Well,
they
yeah.
ask for it?
Well, in
Okay.
theory, it's going to be covered anyway, because that document is going to be recorded. The title company is going to show record that the property is out of probate and that the owner, Sally, is dead, to be crude, and the two daughters now own the property. So do you need it? No. Is it nice to have? Yeah. But ultimately that'll get sorted out anyway. But you're out of the probate. I'll give you a different example real quick on a bankruptcy. Okay. It's interesting because a property that's in bankruptcy, quite honestly, is dealt with almost identical to a property that's in probate. Okay. And if you guys aren't aware of this, one of the things I've had this happen to me, I think twice. It's been a very, very long time since I've had this happen, but it happened twice, and both times was a nightmare. I'm the listing agent. Seller lists the property. We get the property under contract. Prior to close of escrow, my seller files bankruptcy. Okay. Well, once your seller, and you need to ask your seller, by the way, if you have sellers that are in financial trouble, or maybe they get in a divorce or something's going on, you need to ask them, oh, by the way, I know this is difficult and it's really none of my business, but it is my business. Have you thought about, or are you planning on filing bankruptcy? And if the answer is yes, then you need to say, okay, this is the deal. I'm not advising you, but do not file bankruptcy until we get this escrow closed. Because once you file bankruptcy and the property's in escrow, guess who no longer has the ability to sell the house? The seller. It has to be approved by the bankruptcy court. Okay. So when you have a property that, or a seller who has filed bankruptcy, it's treated almost identical to a probate. And now you have to have court approval. And before the escrow can close, the bankruptcy court needs to basically remove the property from the bankruptcy. Okay. They can still go on and try to get rid of their credit cards and all their other unsecured debt and all the rest. They can move forward with that, but that house cannot be sold while it's in bankruptcy. Almost identical process to the probate. Okay. So Irene, your situation, you're past this, so you don't have that. Okay. So let's keep on rolling. Purchase price must be at least 90% of the probate referee. So that gets kind of into that thing. A lot of times the attorney will say, hey, here's my price. Here's the appraisal. If it doesn't require confirmation, as long as it's within 90% of the price. This paragraph, frankly, outlines documentation that you should already have from the attorney. They're going to tell you what sort of rules are going to apply in this transaction. Seller may remove the property from the court calendar if the buyer has not removed contingencies. So again, if the buyer hasn't gone through and removed their contingencies, the seller, or in this case, the seller's attorney, may say, hey, we're not even going to take it to the probate court. We don't want to go there because we don't want to go and get court approval, because the court may not even give approval If the buyer is not fully approved, the buyer hasn't removed contingencies and all the rest, of course, I'm not going to waste my time with it. I will tell you, if you want to have an interesting afternoon, go down to the probate court, sit in the audience, watch it. You'll learn a lot. You really will. I've done it once, but I learned a lot. And they're public, just like any courthouse. So again, did the buyer remove the contingencies? If they haven't, maybe we don't get court approval. Then we've got vesting. How does the buyer intend on holding vesting to the property? That's important because this is part of the approval process. Part of the court approval process will be the probate is selling the property to Jill and Sally Smith, husband and wife as joint tenants, or sisters as tenants in common, whatever it happens to be. So they're going to want to know what that is. And then again, are we going to basically have any mediation, arbitration, whatever it happens to be? And what this is saying is that those portions of the agreement no longer apply because the property is in probate. The paragraphs for liquidated damages, mediation, and arbitration are deleted. Okay. So what they're referring to is they're referring to all of that documentation in the RPA. Okay. So there is no liquidated damages, mediation, or arbitration in a probate. And then, of course, anything else that we might have. And we've got execution for buyers and seller signatures. Any questions? Okay. This portion is for the brokers. Talks about commissions, how we get paid, and all the rest of that sort of stuff. Generally speaking, the commission is going to be set by the court. So as the listing agent, we don't necessarily get to go in and say, hey, this is how much we're going to get, and this is how much we're going to share. That not really how it works. The court will say, hey, this is what you're going to get, and this is how much you're going to share with the cooperating broker. I've never seen it happen any other way than that. Okay. And so that is the actual probate addendum. The next portion is the advisory. We're going to go a little quicker. Anybody have any questions on the addendum? So just to review that real quick, it's basically kind of like a 1.5 page form. Okay. So we've got page 1, which we went through. It outlines everything we need to do. Then when we get to basically the top of page 2, we've got our vesting and signatures. I mean, that's it. There's not a whole heck of a lot to the probate addendum, 2-page document. Okay, probate advisory. Again, this is more of a disclosure / advisory, telling everybody, hey, these are the things we have to be prepared for. And frankly, we've already covered a variety of those. But from a disclosure standpoint, guess what? Seller is exempt from these disclosures. Okay, why? Because the assumption is the seller of the property's never lived in the property. Okay, so mom passed, the heir lives in Texas, hasn't seen the property, doesn't know. However, if the person representing the estate has direct knowledge, you must disclose. Okay, so if you have direct knowledge, you have to disclose. Earthquake guide, exempt. Smoke detectors, exempt. However, the state's still going to require that. So you're the listing agent. We're not closing any transactions. So don't misunderstand that, hey, I don't have to put smoke detectors in there. Nonsense. You're putting smoke detectors in there, even though there's some conflicting statutes with that. Disclosure seller is not exempt from common law and statutory disclosures concerning fraud. So you can't commit fraud. And the deceit is kind of an interesting one. I used this one just a second ago, not realizing it was going to come up. If the seller has knowledge of a roof leak, but over here it says, hey, over here it says I'm exempt from a TDS. Well, if they have knowledge of a roof leak, well, that's deceit. Okay. I have knowledge, I must disclose. Zone disclosure. Again, the seller is not exempt from those. They must disclose. Water heaters, not exempt. Lead-based paint, not exempt. You must go through and do all those standard disclosures as we normally would. Carbon monoxide debate, not exempt. Megan's Law. Again, do they have knowledge? If they have knowledge, then they must disclose. If they don't, I don't have anything to disclose. The RPA then not overrides, but the RPA dictates, says, hey, if the buyer has concerns about that, then they need to go through a take a peek at it. It is kind of crazy, the things that rise to the level of, hey, let's put this in the buyer's seller's advisory or the probate advisory. Apparently, gas and hazardous liquid transmission lines were important enough to make it here. Not sure exactly why they rose to the level of importance, but again, if those items need to be there. Tax withholding, there is no exemption from taxes, right? Death and taxes, never going to get away from death and taxes. So the estate needs to understand that every time you buy and sell, there's tax consequences. There may be withholding involved. This is another reason why not only do you want to have a probate attorney involved, hopefully there's also somebody involved that's handling the tax consequences of the state. From a broker's perspective, we're not exempt from anything. Okay, we still do the avid. We still have agency responsibilities. Our responsibilities are unchanged in a probate, specifically, of course, when it comes to disclosure sides. So we still have to go through and do that. Any local laws may be imposed, still apply. If there's a point of sale inspection, has to be done. If there's a death on the property, the 3-year rule still applies. Don't have a lot of stock cooperatives here. But again, if there's a stock cooperative and it needs to be approved, still applies. Okay. Little bit more definition of a court jurisdiction and kind of how that means, how that is handled. If there's a court, just gives a buyer a little bit more information than what we just discussed. But again, still applies. No exemptions there. The authority to sell the property, does the authority rest with the court? Again, we just spent the previous 5 minutes talking about that. Liquidated damages, probate courts are not bound by independent agreements. We already talked about that. So the liquidated damages clause is stripped out. Okay. Probate courts have jurisdiction over the resolution. So a minute ago, we just said that the mediation arbitration clause is stricken. Well, it's stricken and it's replaced. Who is it replaced by? It's replaced by the probate court. The court themselves will decide if there's an issue arising out of it. So if you're in the deal and the estate and the buyer are disagreeing, well, guess what? You're already in front of you're already in front of a judicial body. So the probate court will basically take over and make a decision as to what that is. And those decisions, to my knowledge, are final. I don't know that there's any disputing that. Okay, I think it looks like we might have, Austin may have missed the signature page on this. So I apologize, I don't have that. My next page should have been the signature block on the probate advisory. So I'm hoping that that's what's next and we didn't miss anything. So any questions on the probate, either the addendum or the advisory? Okay, I'm gonna keep on rolling. So next roll up is, again, they've taken the manufactured home or mobile home RPA, and they've said we're not going to do that anymore. We're going to use the regular RPA, and we're going to attach the manufactured home purchase addendum. And it's crazy. We've seemed to have been doing quite a few of these lately. I do apologize for those of you who have done those. We have not updated the SkySlope checklist, and we need to do that. We're now 3 months behind on that. So we're still showing the manufactured home purchase agreement, that version of the RPA, and that doesn't exist anymore. Now we've got the regular RPA and we've got the manufactured home. So let's roll through this one. Again, we're doing a lot more of these than we've done in the past. So again, this is going to be an addendum to the purchase agreement, dated whatever the date of the purchase agreement is, property address, buyer, seller, again, addendum to the agreement, and the buyer and seller are referred to as parties. We've already gone through this, very similar language. So what do we have? What kind of property are we looking at here? Is it a personal property manufactured home? Okay, well, we want to know that. Or is it real property? Okay, so a personal property manufactured home is a property that is generally not on a permanent foundation. And this is one of those properties that you're basically selling. I use this example as this is similar to selling in a car. Okay, so if it's not on a permanent foundation and it's not real property, which we're going to get to in a minute, then basically what you're doing is you're dealing with the Department of Motor Vehicles. Okay, and it's just an area that's kind of fallen into the real estate licensing rules. But at the end of the day, you're not selling real estate. You're selling a piece of personal property. So what is it? It's a manufactured home. It's either on leased land or rented land, meaning they don't own the land. Okay. It's in a mobile home park. Space number 5, the Martin Mobile Home Park. What's my address, et cetera, et cetera. If you're doing that, this is a very specific type of escrow. We do not do these escrows at Cobalt Escrow. Not that we couldn't, but we just don't, because it is a certain specialty. If you run into these situations, we'll refer you to some escrow companies that do. So you have 2 different types: the personal property, a manufactured or mobile home, or the real property. The real property is no different than selling a single family house, because that it is legally a single family house. Okay. It doesn't matter if it's in a park, doesn't matter whether it's out on its own lot or whatever it happens to be, you're selling real property. So, and it's calling, and by the way, for those, I'm confused, Lance, what's real property? Real property is anything that's affixed to the ground. Personal property is anything that's not. Okay, so that's your basic definition. So it's, by the way, you notice over here, it gives it a parcel number. Up here, under personal property, you don't have a parcel number. You have a space number in a park. Okay, so what do I have? I've got my parcel number. I've got a manufactured home that's worth 100 grand, and I've got real property that's worth 100 grand, whatever it happens to be. So we have to identify what we're selling. Generally speaking, this is pretty straightforward. There can be some confusion. Is it on a personal property? Is it on a permanent foundation? Has that documentation survived? Is it available? Has it been recorded? And all the rest of that sort of stuff. Important to know. Or you also have another one. You have, or is it B, real property, manufactured home, situated, also complete, paragraph, blah, 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 blah. So you could have, I have real property, that's a manufactured property that is a home that meets the following requirements. So we go through and we look at these requirements. Do I have building permit from the local authorities? Is the manufactured home affixed to a foundation? Is it on a permanent foundation? Has a certificate of occupancy been issued? Is there a recordation by the local authorities pursuant to, again, the health and safety code? Charlene and Mike and Colette just went through one of these, and we got all the way into the middle of escrow, and we were still looking for the documentation if it was on a permanent foundation or not. Okay. And if it's not on a permanent foundation, then it's going to be 1A2. Okay. Meaning the manufactured home is not on a permanent foundation, but they own the land. They're buying the land, but the mobile home itself is, or manufactured home is not on a permanent foundation. Okay. So maybe I wasn't clear on that just a minute ago. 1A means I have a mobile home. I'm buying a mobile home, 50 grand, and I'm leasing the land underneath it. So I own the mobile home, but I don't own the land. I'm leasing it. Item 2 is I own the mobile home, but it's not on a permanent foundation, but I do own the land. Okay. So I'm not leasing the land. I own the land underneath it. So basically I'm buying land. That's where that APN number comes in. Paragraph 1B means it's not really a mobile home. It's attached to the foundation. That's what they're referring to. So it is basically a house. Okay. I know it can get confusing, but the main distinction between is it on a permanent foundation or not? It makes all the difference in the world. Additional description. Okay, well, it's built by this company. This is the model number. This is when it was done. The dates are important. I don't have the exact date in front of me. Maybe one of you guys can help me out here. But getting financing on older manufactured homes is very, very difficult. I don't remember exactly what the break off date is. But older manufactured homes can be very, very difficult to finance. That's why they want to know this. How old is it? When was it first sold? Somebody just typed something in chat. 1976. Thank you, Alex. So you've got this issue with the timeline on getting those done. It makes a huge difference. Again, you'll see these HUD license numbers. For those of you guys that were at our market forecast, and Back Porch Homes has been doing those ADUs. Well, the ADUs that they built are designed to be portable or permanent. Okay, well, you got to get that HUD number. The serial number and that HUD label or insignia is critical. So it's this, when they say HUD, that's the exact same HUD, like we think FHA financing, Department of Housing and Urban Development, HUD, that's what they're referring to. So they'll issue that. Additional seller financing. Is there going to be financing in the property? Is it going to be financed as personal property? Is it real property? So again, is there going to be seller financing? Assumption. If it's an assumption of a VA or Calvet, sale is contingent upon seller relieving release of liability. This is where these things can get a little tricky. This is where you take a relatively simple transaction and you can really kind of muck it up with some seller financing or some assumed financing. It's not that uncommon though in these type of properties, especially if it's within a park. If it's within a park, a lot of time whoever owns the mobile home park kind of does all these things behind the scenes. And quite honestly, I've seen some really creative stuff that we would not do. These are the type of things that I don't know. If you want to do that, just go talk to the guy who owns the park, which is very common, by the way, in a lot of these parks. The owner of the park owns a lot of these mobile homes, and he'll buy them and sell them, or she'll buy them and sell them as part of their business plan. Caution to the buyers and sellers, be careful, know what you're doing, know what the obligations on this collateral is. When they're talking mixed collateral here, what they're referring to is you've got real property, the land, and personal property, the mobile home, because it's not on a permanent foundation. Mixed collateral. That's what they're referring to. And that's why the financing can be so difficult on these things. Lenders don't like mixed collateral. I want to lend on the land. I'll give you a loan on the land, which is hard enough to get, but I'm not going to give you a loan on the actual mobile home itself because it's not on a permanent foundation. Allocation of costs. Who's paying for this stuff? Okay, buyer, seller, both. Registration process, title documents. How's that going to work? This is part of a regular contract. There's fees associated with that. And seller documentation and additional disclosure within the time specified. The seller is going to deliver the documentation. This is the transaction with Charlene and Colette and Mike that we had some trouble with. We couldn't find the actual documentation. We couldn't find the permits. We couldn't find the HUD certificate and serial number. And somewhere along the line, these documents, we just had bits and pieces and none of them made sense. At the very end, they all came together and we were able to close. But until we found those, it's very problematic. Similar to, and I know this sounds so crazy if you've never done one, but similar to like on a car where you have your license plate number and you have your registration tags on non-permanent foundation, or even on properties that do have a permanent foundation, the manufactured homes, there's the equivalent of a license plate that's attached to the home, and it's got the HUD numbers and the serial numbers. Well, sometimes these things get knocked off, or they fall off, or someone pulled them off, or they got painted over, or someone put a board on top of them. You can't find them. Major trouble. Okay. Additional real property disclosures. So again, if you're selling real property, all of the real property disclosures go along with it. Okay. Yes, I have direct knowledge of the following problems. Just like selling a house, I'm going to go ahead and I'm going to have to disclose that. Smoke detectors, available manufacturer information describing the method and the frequency and testing. Again, yes, we're putting smoke detectors, carbon monoxide, water heater straps in all of these properties, irrespective of whether it's a mobile or not. Manufactured home transfer disclosure statement. We have our separate TDS, okay, required by law, but this one is specific to the manufactured home. Very similar, but a little bit different. And that is the form MHTDS, manufactured home TDS, not excluded from the disclosure process. Residency application and park rules. So this is where things get a little weird. It's in a mobile home. Hey, I bought the property, but guess what? You have to apply. Maybe it's a 55 and older. Are you going to occupy the property? Well, you're not 55. You can't live here. Or again, you've got to acknowledge what the park rules are, because you're buying in a park. You have to understand that. Park conditions for closing. Does the park have very specific requirements for the buyer to adhere to? What the rules, or what's the parking, and you can't park your car in the driveway, whatever it happens to be. All those things needed. Think of those as CC&Rs, not necessarily CC&Rs, but think of them as CC&Rs for the park. Seller assignment or sublet. Hey, hold on 2 seconds, guys. I'm in the Claremont office and someone's stuck. You looking to pick something up? No, I'm just leaving it for. Oh, you're leaving it. Oh, gotcha. Thank you, sir. Anybody? Sorry about that. I didn't realize, someone was already up there. So can the seller assign or sublet the property? Seller is not assigning or subletting the space the manufacturer to occupy. So basically saying, hey, when you get this space, it's going to be yours. I haven't sublet it out to somebody else. That's what they're referring to there. Caution to occupancy condition. Again, this is a advisory to the buyer. You'll see some very similar language in the RPA referring to the property is sold in its current as is condition, et cetera, et cetera. But you still want to do your inspections. You still want to do a home inspection. And by the way, not all home inspectors will do these. Not every home inspector will go and do a home inspection on a manufactured home. They get nervous from them. So it is certainly a specialty. Occupying a used manufactured home. So again, they're giving you some additional disclosures. Are you comfortable with, what you might find in a manufactured home? Is the quality of construction the same? Does it contain cancerous, chemicals and all the rest of that? It's quite interesting. Okay, so that is, and again, I apologize. Austin seems to have cut off the signature page. That's always my signal that I'm to the end. So there's your manufactured home. I'm going to give you guys a little warning, and I never, ever, ever suggest anybody specifically walk away from business. I will tell you though, I don't know that I would encourage you guys to focus in this particular market. It's truly the entry level of the entry level marketplaces. Generally, the amount of money that's going to be compensation to the agents is on the lower end, and their headaches. So again, if you have a client, you want to help them out, and you're looking for future business, by all means, don't walk away from it. Just like I said with the probate, don't be afraid of them. They're not complicated to do, but generally the compensation is lower. And there are some additional things that will cause you some heartburn when it comes to the traditional sale. Okay, I don't see anybody unmuted. I'm going to keep on going. We're going to go very, very quickly through this. This is a super uncommon. I do not know that I've ever seen one of these in our transaction in our office. So a tenancy in common purchase agreement. Again, it's so uncommon, but in effect, what they're referring to in a tenancy in common, this is how you're holding title. Okay. So you're going to have buyers that are purchasing the property with different interests. So let's suppose Alex and I are buying this together, and we do not have an LLC, or we do not have a corporate entity, or we do not have an entity to take title into this property as part of our business, because this is maybe a business venture. So we're just buying it as individuals, but we're not married, and we don't want to have rights of survivorship, meaning we don't want to hold title as joint tenants. Joint tenants is I die, Alex gets it, Alex dies, I get it. We want to be able to will or sell our interest in the property to somebody else. And we don't want to I don't necessarily want Alex to get it, and he doesn't want me to get his in that effect. So if that's the case, and this is super rare, but if that's the case, you have two different buyers with tenancy in common. So they're going to come in here. This part's the same, talks about the buyer's rights, and then affect the buyer is purchasing what percent. So it could be 50-50, could be 90-10, could be any percentage of the property we want. So I'll just use me as an example. So I'm buying it, and I'm going to get 60% of the property. Alex is going to get 40% of the property. So there we go. So I get 60%. Buyer shall have exclusive right to occupy the unit. Do I get all of it or not? Well, are we even living in this? If both of the owners of the property, who gets to live in it? That's what they're referring to here. Okay. Who gets to park there? Who gets to store there? Who gets to use the deck? Who gets to use the yard? So how are we going to share this property that I own 60% of and he owns 40% of? Are we going to, do we put a piece of yellow tape and I get 60% of the house and Alex is going to live in the other 40%? So you got some interesting things to deal with on that. On the tenancy in common interest, We're basically going to sit back and handle all our paperwork, going to send this over. We're going to make sure, by the way, if you're doing this, buyer will retain a qualified California real estate attorney. Why? Because it's unusual. Buyers need to understand what they're getting themselves into. This is so, I actually did this. I did this with my best friend. I think we were 20 years old. And we bought a property. We bought it as tenants in common. The reality is we probably shouldn't have bought it as tenants in common, but we did. We held it as a rental for a while. We had it 50-50 and we sold it, and it just was like a regular transaction. But you need to get legal advice when you're doing it, just so you make sure you understand. And this is in a little different context, but you want to understand how title gets transferred. That's really kind of the key to this thing. What you own, how you transfer title when you're done owning it. And then, of course, how do the proceeds get split? You might kind of have skipped ahead. Well, when we sell this property, well, if I own 60% of it, then I get 60% of the proceeds, right? Or when I sell my piece to somebody else, now that person owns 60% of the equity and 60% of the liabilities when it comes to the responsibility of the property, 60% of the maintenance, 60% of the taxes, 60% of the mortgage payment. All of those things need to be outlined. And they also may be outlined in a separate agreement, which is why they're saying here, buyer's going to retain a qualified California real estate attorney. Paragraph B, this agreement is contingent upon the buyer's approval of the agreement. Okay, that sounds pretty reasonable. But also limited to the financial disclosures. Oh, wait a minute, there's a financial disclosure. Well, yeah. So I've got to sit back and determine, now I've got two different buyers. How is this property being purchased? By the way, financing something like this, you're not going to get financing like this. The lender, what are they going to give me 60% of the loan and Alex 40% of the loan? It doesn't work that way. So that from that perspective, the financing generally on these is going to be cash, or there's going to be a seller carryback or something like that. If the tenant in common agreement requires the other tenant in common written consent, the sale of the seller's interest, and the seller is going to have 17 days. So again, a little complex, but at the end of the day, this paragraph generally is not going to apply at any rate. So if in effect, this is like an all or nothing deal. We're not going to sell a piece of it. The seller's not going to sell 60% of it to one guy and then going to figure out who's going to sell the other 40%. It can get quite sticky. And as you can see, we don't do a whole heck of a lot of these. How are we going to finance? I kind of skipped ahead here a little bit. Is it going to be a fractional loan? I don't even know where you get a fractional loan. It doesn't happen. You can't go to Brett Reichel and say, hey, give me a loan for 60% and then go to Russ at PRMG and have him give the other buyer 40%. It just doesn't happen. Is there going to be an assumption of a loan? This is generally actually what ends up happening. There's actually generally some sort of an assumption or whatever it happens to be, or there's going to be special financing associated with this. And that's really what this is referring to. So if you're representing any party on this, probably first and foremost is the buyers need to understand what the relationship is. And then even once they understand, then is how is this property getting financed? Let us know where the financing is coming from on this. Otherwise, we're wasting everybody's time. Seller release. 7 days. Okay, this is talking about secured financing where there's going to be an existing loan that's on the property that's being paid off, that needs to be paid off, and that needs to be handled. This is generally what happens on these things. Is there's some sort of seller carryback. The seller is basically going to do financing, be seller carryback addendum, and we will do a seller financing addendum and disclosure. We do I don't want to say a lot of these, but we do quite a few seller financing addendums. We do hardly zero when it comes to a seller financing addendum associated with a tenant in common agreement. I've never seen it, but we will go over the seller financing addendum on more traditional transactions. And then basically cash. Okay. But this is how they get done. Buyer forgoes financing, they're going to get cash. So if you don't have a cash deal, you probably don't have a deal. Is it a condominium conversion? If it is, and then this is where you might find these. And we have so few condominium conversions, maybe like up in the San Francisco or the Bay Area, there's a lot of condo conversions. You might see a lot more of these tenant in common interest. We just don't have them down here. So If you're going to see more of these, you're probably going to see them in areas like that. Financial and operational disclosures. So again, just like any transaction, a seller has stuff that they need to disclose. And this is where they would do that. So if it was, for example, in a condo conversion or an HOA, is where they're disclosing minutes, they're disclosing, appropriate disclosures, et cetera, et cetera. If checked, simultaneous sale of other tenant in common interest. So this talks about on this tenants in common sales agreement, this is referring to not the buyers buying it. This is referring to, hey, we're selling this. We're selling this to somebody else. And we're saying, hey, I'm the seller. I'm selling you a 60% interest in this property. And by the way, Alex is going to stay over here with his 40% interest, or we check the box. Alex and I are both now selling our agreement. So we would use the same addendum if we were buyers coming in at 60-40, or if we were sellers coming in at 60-40. So it's an interesting deal. Wait a minute. No, we're not selling them both simultaneously. We're selling them individually. I'm going to sell my piece. Alex is keeping his piece. Well, how are we prorating the repairs? How are we prorating those taxes? How are we prorating those mortgage? These are all things that Alex and I should have already had understandings and agreements on prior to us getting to this point. Okay. So again, all important stuff. Honestly, I kind of feel like I should probably roll a little bit faster because the chances of you guys going through one of these is so slim, but I do think you do need to at least understand how they work. And again, the simultaneous sale of both of the interests. So if you're going to do it, these are certainly an easier direction to go. Who's going to pay for the costs? It's got to be clarified, just like in any agreement. If there's any discrepancies, what's going to control? Well, in theory, Alex and I have an agreement that's that kind of rules over. We have an operating agreement over what we're doing. Well, that's gonna control. And of course, if you're doing any of these, if you don't have legal counsel, goodness gracious, you're going to be in major trouble. Buyers are acknowledging that they've signed or received the tenants in common ownership advisory, which is what we're going to get to next. And then it talks about the sale of more than 5 units. There's some rules. And again, this doesn't really apply to here. Again, I'm going to go back to my San Francisco example. If I'm doing something up there, if I'm selling more than 5 units, there's specific rules that are going to apply. So your buyers and sellers are going to sign this. Again, it's so uncommon. We need to go through it. I'm going to do the same thing and kind of breeze through the stock cooperative purchase agreement. Very, very similar. We don't really have them in Southern California. You may run into it if you're doing a property up there. So you really kind of sort of want to think of it in the same way. When you're buying into a stock co-op, you actually don't own the property. Okay. You own stock in the property, and the stock in that property gives you the right to occupy whatever it agrees to occupy unit number 4, parking space unit number 4, storage space unit number 4. So we'll just quickly go through this. Are they financed? Again, very similar to what we just discussed. Very difficult to finance a stock co-op. It just doesn't happen. Are there disclosures and inspection? Basically the exact same disclosures. You have to disclose known defects. In a stock co-op, even if the buyer and seller want to buy and sell to each other, well, there's a board of directors. You got to go to front of the board of directors. Are you going to be allowed to move into this building? Do you meet the 55 and older requirement, or whatever it happens to be for a stock co-op? These can get really nasty. Again, I have no experience with them, just other stories associated with it. Is there going to be a prelim? Yes. But the prelim, again, this is a co-op, different than a single family ownership. Are there transfer fees? There's always going to be transfer fees associated with these things. Satisfaction of transfer. Again, it's a stock certificate. I am going to stop here for a little bit because you guys will experience this. Okay. And if anybody has done one of these, just, put something in chat or unmute yourself for a second. It's very common. I don't want to say very common, but you will run into this in Southern California, where you're selling just a regular single family parcel, but there is a stock cooperative for the water supply to the property. And by the way, these things will surprise you. You won't even realize there's a little itty bitty section of Moreno Valley, or there's a little bitty section of Redlands where they're not on Eastern Municipal Water or Western Municipal Water. They're on the ABC Water Co-op that was established back in 1940. And there's a bunch of wells out there. Well, those actually can be kind of cool because you own the property. And just like this stock co-op where you buy this condo, whatever it happens to be, you now actually own a piece of the water company. Okay. And when you do that, what happens? Well, you're transferring the title in that stock cooperative or that water cooperative to the new owner of the home. This is more common in Southern California than you might think. So think of it in a similar fashion. However, this form would not be used in that. I don't see anybody unmuting. I'm kind of surprised that nobody here.
I do.
Experienced. Hey,
I have a
did you-
question.
Okay.
Yes, I did. Would this be similar to having like the water stock where you need a quarter share of water stock, like up in San Antonio Heights? Is that kind of similar to that?
Well, again, I'm using this form as an example. The short answer is yes, but you would not use this form to do that. It would just go on the regular RPA. In the RPA, it would say, oh, by the way, 123 Main Street in San Antonio is serviced by the San Antonio Water Cooperative, and the buyer of this property will receive a quarter share or a 1 share in the San Antonio Water Cooperative. Okay, and there's some transfer fees associated with that. But it is the exact same concept as this. So when you guys do run into that, because you're probably not going to run into this often, if at all, but when you do run into the water transfer, just relax. It'll all get handled. It is one of those things, depending upon the size. There's several of these in Moreno Valley. This is my experience with them. There's 3 or 4 of these in the city of Moreno Valley. They're all relatively small. They service 200 or 300 houses, and there's wells, and it's kind of crazy when you think about it, because you'll have a small little board of 4 people that are in the community that kind of manage it. But generally, it's a good thing. Water's cheap. Have a little bit of ownership in it. There's not necessarily any value there. But yeah, Irene, it's the exact same thing, and easily transferred. I'll give you a little bit of a warning. However, sometimes because these are small companies and there is an actual transfer of stock, it could delay your escrow. So if you do get into one of these situations, make sure you're on top of it early and you're aware of that. Most of the time, if you're the listing agent, the seller will make you aware of that because they realize that it's different. If they don't, then you could be in for a little bit of a delay. Okay, so the buyers are going to sign off on the stock cooperative form. This is just a 1-page addendum. Chances of you guys actually using this one is going to be pretty slim. Again, we're going to blow through the mixed use purchase addendum. In fact, I'm not even sure I wanted Austin to throw this in. This is probably one that I would have skipped. But having said that, this is an addendum that is entirely possible. I'm in Claremont, and I can look down the road here, and I know we've got some units in Riverside and Claremont. In Covina, the Covina office, that's a perfect example. Our Covina office is in some mixed unit buildings. Okay. Now, the way those are more or less laid out currently is they're mixed use, but they're also separate ownership. So for example, the Covina office at the bottom is commercial, and above the Covina office is a residential condo unit. Now, you could use this form for that, but that's not really what this is designed for. What this is designed for is if the house or the condo up above and the building, the business down below is all on one parcel. It's a mixed use. So I'm getting both. I'm getting a condo up top, and I'm getting a business or commercial at the bottom. So form generally kind of becomes self-explanatory. So what am I getting? Well, I'm getting, here's my address, and there's 1 residential unit and there's 1 commercial unit. And what is it? Commercial down below, real estate office, residential unit up before, 2-bedroom, 1-bath, condo, whatever it happens to be. So you would describe that. Who's going to be possession when I buy it? Do I get possession of the commercial, or is it already leased to somebody else, or is it vacant? That gets identified. How are we financing these? This can also be a little bit tricky. Okay, financing these type of projects generally are more expensive and they're a little bit more complicated, but they can be financed. Okay, so how are we going to finance them? What's included in the commercial? Again, if it's a commercial, like our real estate office, well, what's included? Well, nothing. I mean, there's a couple offices based in there, but what if I was a pizza place? Well, maybe downstairs is a pizza place, and included in the sale are all the trade fixtures. Well, what's the trade fixture? Well, the ovens and the freezers and all that sort of stuff. So that's what you'd be referring to on that mixed use commercial. Additional allocation of cost, who's paying for what? Normally you're not doing environmental surveys on a residential property, but you could be doing environmental surveys on the commercial stuff where you need to get a special permit because it's a restaurant down below, that sort of stuff. Safety features, do we have to deal with that? I mentioned a pizza place, it has ovens and freezers, and are there special fire requirements associated with that? Well, maybe so. Water conserving devices, pretty self-explanatory. Surveys and plans, again, think of that on the commercial side. Same thing with permits, think about that on the commercial side. Are we allowed to do that? Structural modifications, frankly, this is what we ran into. This is the problem we ran into getting an occupancy permit on our building. They treated it differently because we had a residence upstairs, and getting our occupancy permit and what we did modification, we put a couple of walls up. Well, did we do it to satisfy the commercial/residential building code? That's what they're referring to. Government compliance, again, same exact thing. In violation notices, are there anything? Do I have a pizza place, a restaurant in a mixed use building that's not made for a restaurant? It's supposed to be office space. So again, these are the type of things that you potentially certainly will run into. Commercial tenancy related, what are we renting? Oh, do I get an income statement for the pizza place downstairs? Estoppel certificates, again, across the board, you guys will be doing estoppel certificates when you're selling rental units. Estoppel certificate basically says I'm buying the condo up top. I'm also buying the pizza place down below. There already are tenants in there. Those tenants need to certify and basically give me a certificate that says, this is my rent, this is my security deposit. These are the things that I've agreed to with the current owner that is going to be assumed by the new owner. So when you're buying mixed use, you're going to want to get estoppel certificates from every remaining tenant. If there's no remaining tenants, no estoppel certificates. Pretty straightforward stuff. Seller representation, seller has to disclose everything that they know. Anything that changes during escrow, well, those have to be addressed. Anything that's going to change. This is obviously more common to commercial type properties. Some occasionally things change. Julio, what do you got?
Yeah, I'm a little confused. So is this like a live work unit where somebody buys the space down below, like a person who runs an art gallery, and then that person lives above the art gallery in a flat?
That's exactly
Or is this something where somebody comes in and buys the flat and the space below? I'm a little confused.
Well, it could be either of those. The example I was using, which is I modified the example a little bit, but Julio, I know you're familiar with the Covina office because you've been there.
Right.
So Covina office has office space down below and a condo up above. Now those are separate ownership interests, but let's, for our example, say it's one space, one title. So when you buy the building, you get the office space down below with Coldwell Banker, and you get the residential unit up above. That's what this is. That's one example. It could be other examples, but yeah, kind of like what you said. I live above and I work below. That's exactly what this would be. This would be mixed use ownership.
Yeah, what's interesting about this is that during the late 80s, the 90s, and then up to just a few years ago, a lot of these mixed use projects were being built where you had live work components, because a lot of these cities that were trying to develop downtown areas really didn't have, the foot traffic or the daily traffic to support, independent retail. So they did these mixed use so that somebody could come in and buy and then run a small mom and pop type of ownership down below. So it's good to know this, because I think as time goes on, some of those units are probably going to become more available on the market as they begin to turn over.
Well, unlike the form that we just went through, the stock co-op or the tenant in common, this is one you guys do have to know. And what Julio just said is exactly what downtown Riverside is doing right now. I don't know how familiar you guys are with downtown Riverside, but if you went to the market forecast last week and you drove down, well, a variety of those streets there, but the, Market Street or Mission Inn or whatever it happens to be, there is a huge number of relatively brand new, some of them are still under construction, and they are exactly what Julio just described, where they're trying to encourage kind of a new downtown vibe, and they're doing exactly mixed use, live above, work below. And there's dozens and hundreds of those units that are built. A lot of what you see in downtown Covina is very similar. Again, our building, the ownership interest in our Covina building on Citrus is not you get both, but that doesn't mean it couldn't be. Maybe the building across the street there is one ownership interest, live above, work below. So you do need to know this. And in theory, you certainly could be running across these. And again, not the type of thing to be afraid of. These are simple transactions with a couple of extra, just quirky little things that you just need to be aware of. Okay, so keeping on rolling through here. Security deposits. Well, why would I have a security deposit? Well, because maybe what I'm buying already has a tenant up above, and maybe what I'm buying already has a tenant down below. So I have security deposits associated with it. Environmental hazard, the same sort of stuff that we do with a residential, but now it might be residential / commercial. What kind of business is down below? And does that business down below create some sort of an environmental concern that I may have? It's so funny. I know nothing about this, so I'm going to show that if I know nothing about it. But every time I walk by or walk into like a nail salon and I smell the stuff that they use to have the ladies' nails done, I'm thinking, my God, these people are going to die, because to me, I am so sensitive to that smell. But think about that. Let's suppose, and this is exactly the case, by the way, in our Claremont, or excuse me, our Covina office. Right next door to the Covina office are some nail shops, and they're using those things that smell. Apparently they're not toxic, otherwise they wouldn't be able to do that. But how would you like to live above that? I tell you, I could not live above that, because if those odors were coming up from my nail salon down below, that would be a problem. Okay, so at any rate, we digress. So what sort of issues need to be disclosed? Everything. Wait a minute. Now we also have the ADA to comply with. Why? Because we have a commercial building. Commercial buildings have to be accessible and have ADAs, are the wheelchair ramps and all that stuff in there. So again, another little bit of a quirky one. This is the signature page on page 3, but important. This is one that you potentially are going to run through a little bit more often. Okay, we have time for a break. I think Austin and myself did not think we were going to get this far. We are not going to break here. We don't have time for a break. So let's see what we have next. Okay, this is where for the next 20 minutes, we're going to kind of do a grab bag, okay? Because all of these forms I want to go through, but these are forms that are maybe not in the order I wanted to go through them in. So we're going to keep on rolling, and we're going to go straight till 2. And I think we're going to run into some property management disclosures. These should go pretty quick. We should be able to knock a few of these out. So if you're doing leases or representing a landlord on leasing their property out, you will be doing bed bug disclosures, and it is exactly what you think that it is. It's just this is a relatively new form. I don't know if it came out in 2018 or before, but I've been doing property management for a long time. This form has not been around for a long time. So what is it? It's exactly what the title says it is. I'm leasing a property. These are my landlords and my tenants. And we are disclosing to everybody that, guess what? You might have a bed bug. And what are we going to do about it? Okay. Gives you a little definition and kind of a description of them. It tells you how long they live, all that sort of fun stuff. And what do we need to do? They can survive for months. So this will be the type of disclosure that you would want to make sure that the tenant gets a hold of, and they make sure that they understand. And I'm going to use the same example, but it doesn't necessarily translate. When I do my mold class, I think you guys were, I did a mold class a couple of weeks ago, maybe some of you were in it. One of my things about mold is, who does that mold belong to? In other words, is the mold a landlord problem because there was a leak that the landlord never fixed? And if that's the case, then that mold belongs to the landlord. The landlord is responsible for fixing it. Or is the mold there because the tenant, lets the shower run and doesn't open a window, and there's been a small leak under the sink and the tenant never told anybody about it? Well, now I have mold. Well, that's kind of the tenant's problem. The tenant didn't remediate the mold problem, therefore the tenant may need to fix it. Same thing with bed bugs. So are there bed bugs in this property because the tenant moved into the property and they were already bed bugs there? If that's the case, my good Lord, guess what? The landlord's going to be responsible to remediate that. Or did those bed bugs get brought into that property from the prior place where the tenant lived? I mean, they literally, when they brought in the mattress, did the bed bugs come into the unit? I know it's a disgusting topic, but these are important things, because when you do property management like we do, man, you don't want to be getting a phone call about bed bugs and how they got there and whose responsibility they are. Mike, you're unmuted. What do you got?
Do you have to provide this form to
Yes.
and furnish the apartment, for example,
Well,
or
I don't.
unfurnished house?
Yeah, I don't do furnished rentals. But yes, and this is one of the reasons I don't do furnished rentals, because I don't want to mess with this. Okay. Where this is a more common problem isn't so much on single family residential rentals, and that's pretty much all we do. Having said that, every single family residential rental that we release out, we use this form. And quite honestly, you guys need to use this form as well. Where this is more, I don't want to say more important, but where it's probably a little bit more pertinent is when you're doing like an apartment building. So in other words, did the bed bugs migrate from unit A into unit B, or from unit 102 into unit 104, kind of a thing? So that's where it can get really messy, because, if it's a single family house, I can say, hey, those are your bed bugs, you brought them in. If it's a 20 unit apartment building, tenant could say, well, they're not mine, and then next thing you know, you got 4 units of the bed bugs. Now who do they belong to? Well, they belong to the landlord in that case, because the landlord's got to remediate them. So it's just a nasty thing. The good news is, I got to tell you, I've had very, very real life experiences with these. They can be remediated, but it can be expensive, and it's just a pain in the rear end. So you're going to use your bed bug disclosure. If there is, this is important, again, especially if you have a multi-unit building, because if they do have them, we want to make sure they don't spread into unit 2 and unit 4 and unit 6. So the tenant has a responsibility to disclose those. So again, 1-page disclosure. So this is the rule. If you're doing rentals, we need this. You need this. Your landlord needs this, and your tenant needs to be aware of this as well. Just one of those ugly little things. Tenant flood hazard disclosure. Again, the tenant property management. Very similar to what we would see on other type of transaction, but this is specific to a landlord tenant issue. Irene, you're unmuted.
I just had a question. What do you do? Do you have to fumigate the place if that takes place?
No, generally
as a
it's,
landlord?
yeah, generally it's not a fumigation thing. It is a pest control issue, though. I mean, for example, if they're in the furniture, that you're getting rid of it. I mean, it's going out. You're basically removing. You're removing the bed. You're removing the couch. You're removing wherever the infestation is, and then you're treating the property. The challenge, of course, is if you saw back here, the lifespan of these little suckers. Where is it? Here we go. So you got this life cycle. Bed bugs live around. They live for 10 months. They lay eggs. They grow to adulthood in 21 days, blah, blah, blah. So, when we get rid of them, do we have eggs that are laying around that we didn't get rid of? It's just a nightmare. Just a nightmare. Not the type of thing that you want to be dealing with. But at the end of the day, what are you going to do? If you're an agent involved in this, or if you're a landlord involved in this, professional pest control service. That's all you can do. All you can do is professional pest control service. Along those lines, any sort of pest control, you guys, that you're doing, let's suppose there's roaches or there's ants or whatever it happens to be, you must have a license to apply that. So if you're a landlord, now you are allowed, obviously, maybe you guys have had ants and you go to Home Depot and you pick up some ant spray. you are allowed as an individual homeowner to go to Home Depot, get some ant spray and spray your own house. But if you're a property manager, or if you're a landlord and there's someone else living in your unit, you should not be doing that. You need to have a license to apply chemicals to treat termites, ants, roaches, bed bugs. So whenever you run into these things, don't take it upon yourself, or don't recommend your landlord go over there and go get some bed bug spray or some cockroach spray. Because now you're going to potentially run into a health and safety issue where a tenant might in effect say, well, they didn't treat it properly, or they sprayed chemicals where they weren't supposed to. So you got to use like the Terminex and the Orkin type companies to go out and handle that. Okay, keep on rolling. Tenant flood hazard disclosure. So again, we're disclosing to a tenant. Ironically, I mean, goodness gracious, with all the rain and all the issues and all the stuff that we've been going on down around here, we're going to have some, the snow starts melting, and it's going to be on the news, probably every day for the next several months about certain communities that are getting flooded, et cetera, et cetera. So what this is we're now renting a property. It's in a flood zone. It's not in a flood zone. So again, property is not located in a special flood zone. Great. So believe it or not, guys, every single property that we manage, tenant gets one of these. And on every property that we manage, with the exception of a few, we use the default. The property is not in a flood zone. But if you're familiar with Moreno Valley, Paris area, and you have Lake Paris, well, most of the properties that are situated in the city of Paris are in a flood zone. They're actually in what's referred to as the dam inundation zone, which means if Lake Paris Dam fails, a lot of that water, or all of that water that's going to come out of Lake Paris, is going to go right into the city of Paris. So they are in a flood zone. So we say it's not in a flood zone, or it is in a flood zone. Okay, property is, where do we find this information? In the NHD. And again, we would disclose that to the tenant, let them know, do they want to get additional insurance? Do they feel comfortable doing that? Our insurance doesn't cover them. Can they even get insurance? So again, this would be a disclosure that you would want to provide if you're doing leasing and the property is in a flood zone. So this is one reason why a lot of agents, I see this, they don't bother to get an NHD on a rental that they're doing. Well, owners should get an NHD and disclose to the tenant, hey, it's in a flood zone, it's in a fire zone, whatever it happens to be. God forbid you don't do that, and then there's a problem. So again, 1-page form, pretty simple. Like I said, we knew we could knock through these pretty quickly. The rent cap addendum. So again, we're back into continuing some property management stuff. We're going to finish today on this. So we'll take the next 10 minutes and we'll go through this. This is pertinent. We actually discussed this a little bit at the market forecast in relation to evictions and such. So California now has a couple of things. These are two separate items. We've lumped them into one. We have a rent cap. How much can the landlord raise a rent in a given 12-month window? And the just cause addendum, which basically says what reasons can a landlord give a tenant to basically vacate and or evict. Okay, so we got two separate issues here, both of which are very, very important. So let's go through them. So there are exemptions. So some of those exemptions are the housing has been issued a certificate of occupancy within the last 15 years. And by the way, these are just cause exemptions. A property contain two separate dwelling units or an ADU with a single structure. Whereas one of them, this would be the ADU where it's a single structure where it's a house and the ADU is actually a garage. Okay, so the garage is one structure. A single family residential property, including a condominium or a plan unit that is an alienable separate from the title or any other dwelling unit noticed below. So again, is it a separate unit? And generally speaking, that's not going to be the case. These ADUs are going to be one unit. So is the property exempt, or is the property not subject to the rent limits? Okay, so that needs to be determined by going through and reading this code. The general rule to this is most of the stuff we're dealing with is not going to be exempt. Just not going to be exempt from these requirements. It's just not. So we got to deal with that. Additional exemptions, housing accommodations where the tenant shares a bathroom. So this is where it would be an exemption if you're renting out a room in your house. Again, we don't really do that. So that's why I say you're not going to run into these things. And single family owner occupied residence, including residents where the owner occupant rents or leases no more than 2 bedrooms. So again, kind of the same thing. This one might be more of like a hostile environment, or this one is like kind of like, hey, we rent out 1 bedroom. So for example, if you come to me on property management and Irene says, hey, you know, I've got a 4-bedroom house and all my kids have moved out and I'd like to rent out 2 of the bedrooms, we won't do that. We just won't do that because, oh my God, the amount of trouble. That's a totally different type of management. And frankly, it's a totally different type of headache. So most of what we're dealing with, none of these exemptions are going to apply. On the rent cap requirements, this is really the one that that most of us are dealing with. And this is that 5% rule or the 10% rule. Okay. Again, whichever is lower. So if you're dealing with rentals today, and by the way, you're like, Lance, I don't do property management. Well, I know you guys don't do property management, but many of you guys are leasing out properties for the landlord on a one-off deal, or you're representing the tenant, bringing them in through the MLS on a one-off deal. They need to understand this. And if you're doing that, you need to explain either to your landlord what the rules are or to the tenant what the rules are. Okay, this paragraph 1 is really the operative thing when it comes to the rent caps. It's actually pretty simple. Okay, so let me try to explain what this paragraph is saying. The rent increase can be 5% per 12 months, up to 10% maximum. But in order to reach the 10% maximum, the CPI, Consumer Price Index, and this, by the way, it's so funny because we're in this inflationary period right now. The CPI must be 5% or more. Okay, so for example, 5% you can raise, no questions asked, but you can't get to 10% unless the CPI is an additional 5% or higher. So for example, if the CPI is 3.2%, well, you could raise 5% plus the 3.2% for a total of 8.2%. That would be the maximum that the landlord could raise the rent during that 12-month window. Now, if the CPI was 7.2%, okay, well, then you can do 5% plus the 7.2%. Well, that gets us to 12.2, but wait a minute, the maximum is 10. So in that case, I could go to 10, but I couldn't go to the 12.2. All right. So 5% plus whatever the CPI, and that can be done annually. So this is the deal. The state of California now has rent control, and this is the rent control. It's 5% per year, not to exceed 10% per year, as long as the CPI is an additional 5% or above. So hopefully that's clear. So if you're a tenant and you're advising a tenant or a landlord, you can pretty much say this is the deal. The landlord can raise your rent 5% a year no matter what. Period. Boom, done by law. There's your civil code, 1947.12. But they could also go all the way up to 10 if the CPI is an additional 5% or higher. So whatever, 5% plus CPI. No questions asked, it can be done. Now, the flip side of that is you can't go above 10 no matter what. So if the landlord says, hey, you know, you've been there for a long time, but I haven't raised your rent in a few years and I fell asleep at the switch and you're 25% below market, guess what? I'm going to raise your rent 25% tomorrow. Can't do it. Can't do it. The maximum would be the 10%, assuming the CPI. So you do have a lot of landlords out there that have been asleep at the switch, that this rent cap requirement has got them behind the 8 ball, which is problematic. So there's your rent cap. The second part is the just cause. And in effect, most of the time this is referred to as for eviction. So you have at fault. So these are reasons that you can evict somebody. Okay. They haven't paid their rent. That's called at fault. So you can evict somebody if they haven't paid the rent. They're in breach of material clause in the lease of the lease. There's 10 people in the property when they're only supposed to have 2. Okay, that's an at fault. They're not maintaining my property. They're destroying my property. They're doing whatever. That's at fault. They're committing waste. Again, they're destroying my property. Committing waste basically means they're abusing my property. The tenant has a written lease that terminated after January, by the way, January 1st, 2021 is when this law came into effect. And the written request or demand by the owner of the tenant refused to execute the written extension. So in other words, you're not extending. You know, I've asked you to extend the lease, your lease is up. You're not extending, you refuse to extend. Okay, great. That's just cause. I can ask you to, I can basically evict you. Okay. Or you're doing some sort of criminal activity. Police are there all the time. You've been arrested for drug distribution. I can evict you. So those are just cause evictions. Oh, oops, they continue. You're subletting without my permission. You're not letting me come into the property. Okay, I'm trying to come into the property to do improvements. You're not letting me in. I can evict you. Okay, you're using the property for unlawful purposes. You've got a house of ill repute. You're running a prostitution house out of my house. You've turned my house into a car mechanic shop. That's not what it is. Okay, or we've given you notice to terminate, or you've given us a notice to terminate, but you haven't delivered possession. So those reasons, the A, B, C, D, E, F, G, F, okay, all the way through here, through J, those are what's referred to as at fault reasons to ask a tenant to leave. So you can give them a notice to vacate, and if they don't, you can evict them for those items. Then we have the no fault reasons. Okay, the no fault reasons basically, you're going to have a pretty difficult time evicting a tenant for what's referred to as no fault. Okay, so actually, I'm sorry, let's back up. These are reasons you can give them. So the at fault is the tenant's done something wrong. They are at fault. Okay, I can also give a tenant notice to vacate and or evict for no fault reasons. In other words, the tenant is not at fault, but you got to be careful on these, because if you're making these up, or you basically are using one of these reasons to unlawfully ask a tenant to vacate, the landlord or the management company, whoever's involved in this little, ruse, can get in major trouble. So what it is, hey, tenant, you have to leave because I intend on occupying the property, or my spouse is going to occupy the property, or my children are moving into the property. So this is the deal. If you give a tenant notice to vacate, and the reason you give them is, I'm going to move back into the house, or my kid's coming back from college and they're going to move back into the house, and then they don't do that, and then the tenant drives by after they moved out and they see that there's a for rent sign in the property, and wait a minute, I thought Lance's kid was going to move in. Man, oh man, there's going to be some major penalties for that, because what they're trying to avoid is they're trying to get landlords to not to evict tenants just because they want to raise the rent and they want to put somebody else in there. So that's the reasoning behind this. So if the landlord lies, they're going to get in big trouble. Now I want to withdraw the property from the rental market. I want to terminate the lease. Basically, I don't want to be a landlord anymore. That's fine. But if you give the tenant the reason, hey, I'm asking you to leave, or I'm evicting you because I don't want to be a landlord anymore. Well, again, after that tenant leaves, you better not put a for rent sign in the yard. Okay, if you put a for rent sign in the yard, you're going to be in trouble. So you either have to take it off the market completely, which generally means I want to sell it. Okay, but you better sell it, or you better move back into it, or you're going to run into some trouble. Now, again, it's unsafe. Governments come out and they red tagged it. I got to do some improvements. Okay, those reasons are good. Or again, I want to tear the house down and I want to build a new one, or I want to substantially remodel, or whatever it happens to be. Again, you can do that as well. So be very, very careful. The one that we run into all the time, quite honestly, is we have landlords lie to us all the time. And because they realize that they can't just evict a tenant for no reason because the rent's too low. Hey, they're paying the rent, everything's fine, they're taking care of the property. So they said, well, just tell them I'm going to move in, or tell them my kid's coming home from college. And then the tenant moves out, and the next day they say, oh yeah, hey, guess what? My kid's not coming home from college. Let's re-rent it. Let's raise the rent, $800. Oops, major trouble. Don't want to touch that with a 10-foot pole. So those are your at fault, no fault. And then you've got just cause notices, a curable at fault. Curable at fault is exactly what it sounds like. They've done something wrong. They haven't paid the rent, but they can cure it. Okay, well, hey, they paid the rent. Or, hey, you told them you got too many people living in the house. but they can cure that. Okay, I'm sorry, I didn't realize. Next, thing you know, all those people move out. So now they've cured it, so they get to stay in the property. Tenant payments pursuant to no fault. Again, I just kind of gave you that example. They've cured the at fault problem. And that's basically the end of the form. We've got a disclosure here, landlord tenant signs, and a go about our business. Okay, it's 2:01. We're going to have the rest of this course is going to be outlined before next Thursday. So you guys are going to know exactly what forms we're going to remain. I am going to do a better job ordering them. I did not intend on going through property management forms today. So between now and next Thursday, we will have the remaining, I think, 2 weeks of the course laid out. I will actually start to reorder the course in preparation for the next contract college, and maybe some of you guys might give me some input on how that works. I realize we've got a few things out of order that I would have done differently, but anyway, I'll pause for just a second. Anybody got any last minute questions or comments? Otherwise, we're going to call it a day. I don't see anybody unmuted.
Hey, Lance, this is Julio.
Hey, Julio.
I just want to thank you. Your examples and your in-depth knowledge takes a lot of dry material and brings it to life. So I really appreciate it.
You know, I
Good
do
stuff.
appreciate it. It's funny, Norm and I would always have these conversations, and one thing, there's a bunch of side benefits to doing these classes, and it does, you know, we all love Norm. I mean, everybody in here has spent time with Norm and has a soft spot in his heart, but I did a whole bunch of these classes over the last 12, 13 years in person live with Norm. Some of you may have attended some of those live classes we did. But one thing Norm would always say, and it's true with me too, I actually enjoy teaching these. You know, hopefully that comes through, and I'll take Julio's comments as it is coming through. But another thing with this, guys, 100% of my examples are real examples. I mean, most of you guys know this. I've been doing this for 36 years. Between all of the business that I've done as an individual or my team or Drew, and I'm not talking about Coldwell Banker Town and Country. I personally been involved in, I don't know, 7,500 residential transactions. I've done a lot of business, a lot of Fannie Mae, a lot of Freddie Mac, a lot of foreclosures, a lot of hedge funds, just a lot of past clients. So it's a lot of business. So the great news with that is I got a lot of stories. I got a lot of crazy things that I can laugh about now, which at the time I cried about. Trust me, I know your pain when you're in those deals and you're just pulling your hair out. And I've been there, done that. So bringing some of those stories to life, it's kind of like a stroll down memory lane. I do enjoy telling them. So anyway, thank you for the comment, Julio. Appreciate that. Okay, guys, I don't see anybody else unmuted. So we'll be back here next week. I'm pretty sure 2 more weeks we'll be through, and then we'll do like a recap. And then if you guys want to help me kind of organize the next contract college, we might take like the last 30 or 40 minutes of the very last class. And I would love for a few of you to stick around and say, okay, hey, Lance, what do you think about this? Or maybe we should do this first and do that second, or let's take the property management and push it out. I would really love to get that input. So, but anyway, we're very, very close. Okay, guys, have a great day. Go sell something, and we'll see you next time. Bye-bye.